Good morning everyone and welcome to the catch-up final hearing today, the 7th of April. We've got a variety of things to deal with today, and one of the reasons why we're a few minutes late is just having a look at what we'll deal with step by step as we go through. And today we've got Alliance speaking to us first, followed by Environment Southland and Federated Farmers taking us through to lunch, and a number of other matters to look at that are in the reports, all of which are available online. So I guess we'll make a start, and I think that we have Doyle Richardson online from Alliance. Good morning and welcome. And all we see coming up. So good morning, Doyle. In your hands in terms of what you want to talk to today. Thank you. Is it possible that you can't hear us?
Also, Shakai, can you send me an email copy of what came in this morning? Yeah.
So we'll try again. People online able to hear us now? So Doyle could hear us at 9:09, it said. So good morning, Doyle. I gave a brief intro saying we've got a mix of things that we're dealing with today, and I see that your picture's now coming up. So in your hands to hear from you. Thank you.
Morning. Thanks for the opportunity to speak to you this morning. I just sent the hearings administrator a hearing statement, which I'll speak to this morning. I don't know if you've got that.
Yes, we have a copy in front of us. Thank you.
Okay, so I'll just read through that if that suits you.
Okay.
So I'm Doyle Richardson from Mitchell Dash. We act for Alliance Group Limited, who lodged a submission and for further submission on the proposed plan. This submission and further submission related to the provisions of the Natural Hazards chapter. So I'll just closing some emails. Yeah, related to the Natural Hazards chapter of the proposed plan, it was heard at hearing stream 11 on 21st of February 25. The hearing statement, this hearing statement has been prepared to provide comment at the request of Alliance on the signed joint witness statement prepared by the Gore District Council and Environment Southland in response to the panel direction in minute 43. So by way of background, I prepared a statement of planning evidence at the request of Alliance regarding the provisions it submitted on that are within the scope of the topics in hearing 11. In my opinion, the provisions of the Natural Hazards chapter as notified required amendments to appropriately provide for existing activities and potential future industrial activities associated with the meat processing plant Alliance owns and operates in Mataura. In summary and of relevance to this hearing statement, I recommended amendments to Rule NHR6 to provide a more permissive consenting pathway for buildings containing non-sensitive activities within the actual and potential inundation area. This was to reflect that non-sensitive industrial activities represent a lower threat to life and can typically be designed to be less vulnerable to flooding and inundation compared to sensitive activities. Following the hearing, the panel released a minute stated that they considered that, or that you considered the natural hazards chapter needed to be reworked. In summary, you directed expert witness conferencing between Mr. Osborne on behalf of Gore District Council and Mr. Roy on behalf of Environment Southland to confer regarding several matters and identify areas of agreement and disagreement to be considered in this hearing. The panel invited any other expert planning witness to be involved in the conferencing should they wish. Alliance expressed their interest to be involved in the discussions and review any draft provisions to the extent that they relate to A, the definition of significant risk and its relationship with sensitive and non-sensitive activities, and B, amendments throughout the natural hazard chapter to give effect to the new definition of significant risk, which may include separate objectives, policies and rules for sensitive and non-sensitive activities. I received a copy of the joint witness statement prepared by Ms. Banhedi and Mr. Roy on 1st of April 25 and was advised by Ms. Banhedi to share any comments or concerns the Alliance might have in this hearing. This hearing statement therefore sets out my comments on the consenting framework and areas of agreement and disagreement set out in the joint witness statement. In regards to the definition of significant risk, the main area of disagreement between Mr. Roy and Ms. Banhedi relates to the return period. Mr. Roy considers a 1% AEP return period may reduce scope issues, while Ms. Banhedi considers a 0.5% AEP return period as current best practices and is supported by expert evidence. With respect to the Southern Regional Policy Statement, I note that the explanation / principal reasons for policy NH5, which relates to significant risk from natural hazards, it states that areas potentially at significant risk include, but are not limited to, areas that have flooded to a depth of more than 100 mils previously, marine and riverine inundation, but exclude urban stormwater inundation in reticulated areas, and for which the likelihood of inundation has not been reduced by flood alleviation works designed to protect the area from floods with a 2% or less annual settings probability. From my reading, policy NH5 provides direction that areas at risk of flooding during a 2% AEP event is an appropriate threshold for areas to be considered at significant risk. From the flood mapping by Environment Southland, it appears that Alliance sites are protected from a 2% AEP event by stopbags and existing infrastructure, so wouldn't fall into the significant risk category according to the Southland RPS. However, if a 1% or 0.5% AEP event is used as a test instead, parts of the site fall into the significant risk category. This, coupled with a potential non-complying activity consenting pathway for all buildings, would result in an overly conservative approach that may present an unnecessary barrier to development in some locations, which I'll discuss further below. So amendments to the Natural Hazards chapter. With respect to the proposed framework of the Natural Hazards chapter, I understand the key area of disagreement relates to the consenting approach between sensitive and non-sensitive activities. Mr. Roy considers that the relevant policies of the RPS do not differentiate between these activities and that non-sensitive activities should also be avoided in significant risk areas unless there is a functional and operational need. In contrast, Ms. Banhedi considers the policies are less absolute and that non-sensitive activities within significant risk areas can be managed as restricted discretionary activities within managed policy direction. In particular, Ms. Banhedi highlights that the explanatory text of policy NH5 states some form of development, residential for example, will be more at risk and more inappropriate than others such as agricultural or boundary adjustment subdivision. Overall, Alliance supports the view of Ms. Banhedi and disagrees with the position of Mr. Roy for the following reasons. The Mataura plant and its associated activities are industrial in nature and do not contain any sensitive activities as defined in the proposed plan. Any development of the site therefore falls under the category of non-sensitive activities. The Mataura plant is located within a general industrial zone of the plan. The purpose of the zone is to provide for a range of industrial and ancillary activities which fulfill an important role the local community and providing for employment opportunities. The objectives and policies seek to enable a range of light and general industrial activities which support the purpose of the zone, which is reflected in the rules through a permitted consenting pathway for light and general industrial activity. If the significant risk definition adopts the 0.5% or the 1% AEP return period, then I understand the Mataura plant will be considered a significant risk area. If there is no distinguishment between buildings containing sensitive and non-sensitive activities, this would mean any building within the Mataura plant would be a non-complying activity regardless of scale, and a consent application would need to demonstrate a functional and operational need for an industrial activity to be undertaken in an industrial zone. As mentioned before, this seems to be an overly conservative and restrictive approach that is contrary to the purpose and provision of the underlying general industrial zones, which seek to provide for and enable industrial activities in light of the benefits they provide for the wider community. As I noted in my statement of evidence at hearing 11, I do not consider sensitive and non-sensitive activities should be subject to the same consenting pathway. Buildings containing non-sensitive activities represent a lower threat to life, given they are generally not occupied and do not include residential activities. Regarding concerns of threat to property, I consider this as a risk, mostly a risk borne by Alliance for any development within the actual potential inundation area that is not sufficiently protected by flooding and inundation. Alliance has been operating at sites that will be affected by the proposed plan framework for over 100 years. Activities at the site have been designed, developed and operated in a way that means they are still there today and are therefore accepting of the risks that come with that. This long duration of operation is not dissimilar to the timescales that are sought to be managed through the proposed rules, so the risk is well understood through experience. Applying a non-complying activity status to activities that have occurred at the site, recognising that Alliance may be different to other sites, for over 100 years doesn't reflect what is on the ground, nor does it consider the significant assets and investment already made at the site. Future development needs to be contiguous with what is already there, so avoiding placing new buildings in this area is impractical. Regarding potential displacement and flooding effects on other properties, a separate consenting pathway for non-sensitive activities within sensitive risk areas, such as via an RDA activity status, could still require an assessment of flooding and displacement effects on neighbouring properties for any new buildings located within a significant risk area, which would assist in giving effect to Clause B of the RPS policy in NH5. In summary, I consider that the distinction between sensitive and non-sensitive activities will provide an appropriately enabling pathway for the establishment of industrial activities within buildings at the Mataura plant, and avoid a situation where industrial activities within an industrial zone are non-complying activities, while also ensuring that potential flooding and displacement effects on surrounding properties are still considered and assessed as part of any consent application. And I thank the panel for the time and the opportunity to provide feedback on these matters.
Any questions from the panel? Glenys? Maria?
No, I just want to thank you. It's really helpful to have your statement this morning to refer back to. So I don't have any questions arising from it. It's very clear.
Okay.
Kia ora.
Doyle, I was just looking up the industrial rules and haven't found what I was looking for yet, but the issue that we've got through much of the plan, the standards talk about compliance with the 0.5% when it comes to erection of buildings. So the way that the rules are applied appears that there's no submissions actually to that figure, notwithstanding what's in the RPS that talks about the 2% flood levels. And the advice that we've got is that the 0.5% is best practice. My issue that I have with it is that it may be the most common practice, but it's best practice. So we've probably got a scope issue that we need to come to grips with in the way that we deal with what I see as a series of conflicting positions and figures that we're having to deal with in the plan. Just wondering if there's anything that you actually want to add that might help us. Thank you.
No, probably. I probably don't really have a lot to add on that particular issue, other than I guess there has been a bit of uncertainty about how this rule framework and that will apply to the site, and that's sort of changing a bit over time, and it's probably, I think that there combined with the actual consenting pathway is probably, I guess, shifted quite a fair way, and there's been quite a lot of uncertainty there, and I wonder if that uncertainty might be shared by others that aren't involved, or they won't know about this if they haven't been involved in this process from the start, I suppose. So, but in terms of whether or not it should be a 0.5% or 1% or whatever the number is, I suppose the key issue for a lot that the Alliance is concerned about is using, I guess, a more conservative number, which would be the 0.5% coupled with a non-compliant activity status. I think results in quite a conservative, overly conservative management framework, and that's probably the activity status that is applied to the activities is probably the main concern of the Alliance.
Right. So So when I look at natural hazards policy 2, that talks about managing development and subdivision in all mapped actual potential inundation areas. So that's just talking about the areas that are shown in the plan. But then it goes on to say 3, requiring a minimum floor level for buildings above the 0.5% annual exceedance probability design level. So I'll need to check whether there are any submissions to that actual policy. So I guess just to flag that, but we can't take it anything further today. So given there's no further questions, I'd like to thank you for the input that you've had through this process. From Alliance point of view, there's been some key issues in terms of buildings and proximity to the river and the presence of the concrete wall. There's been other issues over the zoning of some of Alliance's land, such as the water storage area, is it, at Mataura? And also some issues raised with regard to providing for workers' accommodation within the industrial zone. Are there any key messages relating to other matters that you want us to have front of mind as we move on from here?
No, I think we've sort of, it seems like through this process that I guess the messages and the thoughts that we've been trying to deliver are landing, I suppose, and so I'm pretty comfortable with where things appear to be heading, I suppose, with the plan in terms of how all of those matters that you've just highlighted there are being addressed. So there's nothing that really stands out to me. I guess this natural hazards, just how that's dealt with is probably the main one that I'm a little bit unsure about at the moment, how that's going to land. But that's, that'd probably be about it. But, so appreciate the opportunity to speak to the panel and also the council officers at times as well through the hearing process. It's been really helpful. So it's been a good process.
So thank you for that feedback. We've actually got Environment Southland speaking next with regard to the latest plans that we received on Friday, which showed the 0.5% scenario from their flooding model, so that may be of some interest to you. So thank you for the input that you've had through the process, and we'll move on to talk to Marcus, who's sitting at the back of the room. So thank you, Doyle.
Thank you.
Marcus, please come forward. Now, I've asked if the plans that's set through on Friday can actually come up on screen at some point. If you can talk us through what you have sent, and then there's going to be, I guess, a series of questions that flow from that. We also need to be understanding of the joint witness statement in terms of the rationale, or where there's disagreement, and the rationale from your point of view. And at that point, we might talk to our advisors as well, so that all questions that we're dealing with, the natural hazards issue we'll deal here this morning, and it might take a while, but from the point of view of the panel, there's a lot of information, some of it of a technical nature, that we are struggling a little bit with at present. So it's an opportunity to ensure that in fact we're fully understanding of what we've got and what it means. So if you can give us an overview first in terms of what we now have in front of us.
Yes, certainly. Thanks very much for the opportunity to come and speak to us. Was hoping it would come through a wee bit sooner, so there'd be a bit more time to digest it than over the weekend, but that's just the way the modelling worked out. So effectively, Matt, who you heard from earlier from the Environment Southland presentation earlier last month, he's gone through and worked the 0.5% AEP model through Gore and Mataura townships for both depth and velocity, and he's also provided a set of maps with the hazard profile or hazard risk profile combined with the velocity and depth in accordance with the Australian profile that had those different colours on it. So I sent through 6 maps on Friday afternoon.
6 series of maps.
Yeah, 6 maps with three maps on each, or 3 maps in each series. So I could potentially jump on Teams and share my maps if need be as well.
Yeah, that might be helpful, because you can use your pointer on your machine to
Right.
go to any area. I initially thought that our admin team had sent me the same series of maps 3 times, until I looked at the fine print and the description and saw that we have maximum depth as well as flow data, and then a combination of the 2 for each of the series.
Yes, correct. Yeah. There we go. We managed to get the maps up. So that's the 0.5% AEP model for the flow. Is it velocity, that one? Can you zoom in a little bit? I'm just trying to read the text at the bottom. It says map title. Oh, yeah, so that's the hazard map showing combined velocity and depth. I wonder whether it's probably best to start with the depth series and go through the depth series and the velocity series, and then round back to the peak hazard map, which is the one you've got on the screen.
And I think that's series 2 in the maps.
Sorry, is this the one you're looking for?
No, if you could go just the velocity maps, that's the combined velocity and depth series. If we start with the...
I might, that email didn't quite make it through to me on Friday, so I might just have to check from the website, so it just might take me a moment.
Okay, thanks.
Marcus, would you like us to send you the link so you can jump in and
Yeah.
Yeah, that might be the way to go. Thanks.
I do note that the maps we've got, therefore probably the earlier ones, didn't include the influence of the Waimumu stream coming in at Mataura. It took me a while to work out why the plans actually showed less of an area subject to flooding than the area shown as subject to inundation in the notified plan.
Yeah, okay.
So I think I've now looked, sorry, did you want the peak hazard, peak speed, peak depth? Which one?
The depth.
Peak. What?
Yep, peak depths. Yeah, for Mataura or Gore, we could go either way. Yeah, that's the one.
That what you're looking for?
Yep, that's the one. So if you could zoom in a little bit, it's reasonably well zoomed out. So effectively, what this map's showing is a 0.5% AEP flood down the Mataura River. So that's 1 in 200 year return period. And the depths, or the key down the bottom left-hand side there indicates the depth of water indicated at the different locations within the township. So you'll see there's quite a big area in the commercial precinct area that is in the yellow, which is sort of 2.5 to 3 metres in depth. There's pockets which are turning orange, so 3 to 3.5, and if you look at it closely, where the current Gore District Council building is that we're sitting in is between 2 and 2.5 metres, roughly, depth through the township with that sort of return period. You'll also note in the East Gore area, there's quite a depth of ponding behind the stock bank. Where the mouse is now, in red and yellow, and it also flows over through East Gore and then backs up behind the railway line, and then eventually flows across into the Waikaka. And then as you track down onto the next map, thanks Mishka, you can sort of see the impact further on the south end of Gore with wastewater ponds reasonably prominent and a couple of wee runners working their way down through the floodplain there.
So the land between the racecourse track and the highway, and also to the south, what's the two blue colours, the light and the dark?
So light blue is 0.01 metre to 0.5 metres, and the darker blue is 0.5 to 1 metre.
And what that shows is that when compared to the data we had originally from Tonkin and Taylor, it actually showed a greater depth in that area. And so the recommendation was that as part of the industrial area adjacent to the highway, there should be a no-build area. And what came through from the 2% and 1% flood data, and also I guess here as well, is that the depth of water being modelled is less than previously thought. I'm fairly certain we've had a recommendation that the no-build area is no longer required in that area. Is that your understanding as well?
Yeah, I guess the Matt indicated when he was presenting his evidence in March that the roughness of the model was quite conservative, so he was sort of indicating that the way the model's been developed, there was sort of no constrictions with debris on bridges and those sorts of things. So in a life-scale event, there would likely be erosion and build-up and trees and other things potentially snagged in the bridges through the various stages through the catchment, which may make the flood worse than the model was showing. But effectively, in terms of the floor heights through the air, or removal of floor heights through the air, I think the model gives a pretty good indication of what the likely risk is. So it would just be a matter of getting the right indicators in the plan around floor heights if there was a building to be located in there, whether it was sort of hazard sensitive or not hazard sensitive.
So how do you expect the panel to use that data that we now have on the plans?
So effectively, the notified version of the plan indicated floor heights above 0.5% AEP for residential dwellings, I believe. I don't think it had anything in the industrial zone signalling back to those that flood height. I guess the Environment Southland position was to try and avoid upzoning or enabling further zones or more permissive planning regime to establish in areas that were known to subject to natural hazards. So prevention's better than cure, I guess, from an Environment Southland perspective. So I guess my evidence would be that the panel should look to avoid significant risk and then manage it otherwise, as per the RPS. In the area between the racecourse and State Highway 1, I think it's in a space where it could be managed. That flood risk could be managed in terms of depth, and then as we work through into velocity and then overall hazard profile, it would be worthwhile just double checking that other information as well.
The Environment Southland has lodged a submission to every zone saying you should not be upzoning if there is a significant hazard. Now, the plans you've supplied north and south of Gore and Mataura and nowhere else. So elsewhere we're dependent on the Tonkin and Taylor data, dependent on the what's shown in the notified plan, but the provisions in the plan just refer to areas subject to actual and potential inundation in the notified plan, and the legal submissions that we've had is that in terms of what Environment Southland has submitted, we can't go beyond the areas that are shown as being subject to actual potential inundation, but we should be taking, if I understand it correctly, we should be taking the information you're using for how we deal with activities within what is shown in the plan as actual potential inundation.
Yeah, I guess the natural hazard maps that were notified were a point in time, and information's only gets better with the time and as we move forward, and I guess that's where the RPS tries to deal with that through using the best available information instead of relying on historic information to say, oh, it never really floods there. If you have that approach forever moving forward, then there wouldn't be much need for doing additional modelling because you would know it all from previous floods. So I guess, in my view, the risk is the modelled risk. I mean, it's a pretty detailed model, this one from Environment Southland, and it's great. It's for those couple of townships, but over time there will be better information become available for the rest of Gore. So, yeah.
Right, so looking at upzoning where the notified plan changes some of the zonings, if we can just go back up one plan, please, so the Gore Township shows up. And if you look at East Gore, the lime green, the orange and the red, and zoom out a little bit, and through the main residential area of Gore, the business area, again the lime green. All those areas are shown as medium density. So we've actually, I guess, upzoned them from residential to medium density. Is what you're promoting then bringing into question that zoning?
Yes.
And something I'll get some feedback from the planners as well. Are there any other areas shown in the ES model where there has been an upzoning that you think the panel should be looking at that zoning?
There was a development area proposed in South Gore as well. I think it was in relation to near down by the racecourse, but effectively the modelling's indicated that it's probably not as bad as initially thought. So maybe a bit of a tweaking around the boundaries or setting some mitigation requirements. I guess the submission was generally trying to be quite broad to indicate that we hadn't seen the model yet when we made the submission, but I guess the general presumption was that we know that the flood model is going to provide some outcomes that we probably didn't want to see or didn't want to know about, but ideally prevention is better than cure in the situation of not amplifying or intensifying development potential within areas of natural hazard is overall going to be better for the community and prevent, those signals.
Sorry, but there's a clear difference between this upzoning area and the ones we were just talking about that are lime green. So when I look at the 1% AEP model and the 0.5% for the South Gore development area, they don't show a huge amount of difference, which suggests to me that the land might be quite resilient there, really. And your idea that manage is the appropriate response for the marginal hazard area at the frontage, would you agree that that's where we should be landing, i.e. it doesn't fall into the category of a void for that upzoning?
Yes, correct.
Do you see a change from rural to rural lifestyle as being an upzoning, particularly around areas of Mataura?
Yes.
Do you see the provisions in the plan enabling a second residential unit as being a form of upzoning, notwithstanding government's recent announcement?
Yes, I would see that as an upzoning.
So would you expect within the flood protection area, particularly at Gore, that the ability to have a second dwelling on the site should be a non-complying activity?
Yes.
Arising from those maps, are there any other zoning issues that you think arise?
No, I guess we tried to have a pretty broad approach. I'd have to have another look through the more detailed individual zones, but I guess we tried to have that placeholder and go anywhere there's upzoning or increased development proposed within the flood zone, we need to manage the risk in accordance with the RPS. So I haven't got that detail of exactly where those zones sort of lie and start and stop. So it's probably the extent of how much I can answer that question.
Okay, before we go back to the other issues, are there any other questions from the panel in terms of the maps?
I wonder whether it's worthwhile, just before that question, you go into because I guess the primary thing we were looking at in terms of the joint statement was around the depth, because the plan had the avenue of putting a floor level on based on the 0.5% AEP. So I guess the Environment Southland model has the depth and the velocity, and then the combined depth and velocity. So it's probably around that scope of how much scope there is to include the velocity and then the overall risk, because depth is only one component. in the modelling it didn't look like the velocity was super high, so I guess what we're sort of, when we're trying to have a conversation around the joint statement, was around, you know, if we try and look for what height is where the significant kicks in, was it H4 or H3? We tried to work through that as well, to identify the area where significant would kick in and potentially non-complying, but then where you need to provide, you know, more enabling framework, and a mitigation approach would be more appropriate. So I think that was around 1.2 metres, so the areas that are in the lighter of the light greens. It's difficult.
And so 1.2 therefore being the raised floor level for anything outside the significant risk area.
Yeah, so 1.2 was the height of the flood, but the rule didn't indicate how much above the 0.5% flood height the floor needed to be.
So it would be at least 1.2 metres, but maybe higher.
Yeah, potentially higher.
To get, yeah. And so in the last hearing, Ms Hampson sort of laid a challenge for us in terms of understanding the boundary of the notified inundation area would trigger the minimum floor level response, but the 0.5% AEP might extend beyond the boundaries of the notified inundation area. So do we have a sense of the comparison from these maps of what falls outside the notified inundation area that would fall into the significant risk category or otherwise require elevated floor levels?
I don't have a clear understanding of that, just because the modelling of the 0.5% came through on Friday afternoon and I sent it straight through, so I haven't had a chance to digest the extent of what that would look like over the weekend.
And so that would be potentially another reason for revisiting this through a variation or a plan change to address that point.
Yeah, well, I guess when the plan was notified, there was no clear understanding of the 0.5% AEP, but the rule still went through. So I guess it's just around that optics from what was notified as this is the intent of where we're going, but not actually knowing the potential impact of that rule when that came in. Because now we've got at least a model for Gore and Mataura townships that indicate what that 0.5% AEP would look like. I think in terms of natural justice, it would be probably beneficial to go through a plan change process to provide that level of understanding and awareness of the implications associated with that floor height level if that rule was going to continue.
And it's at the pleasure of council whether it goes through that process. I had a quick look, and there was a plan that actually showed the differences, and given the topography from the river heading west that rises up, it's not a lot of difference in the area of land that's affected, it's just the depth of water. So where you've got a hillside, the water will just get a little bit deeper over the same areas as to what was there before. I think though that we probably need to set aside Building Act issues. So regardless of what's in the plan, when it comes to the Building Act, the information that you've given us we can't unknow. So that's rests with council then in terms of how the building department and how the planning department uses it, both for building consents and where limbs are asked for, or PIMs. So any other questions, just in terms of the maps? Because
yes, I have to ask the question that others will ask. How would you respond to people that say, Look, I think your maps are overstating the potential because historically that's hasn't flooded. What would your response be?
Yeah, I guess we can only rely on information from our history to understand what's gone through in the past, but the information that we've got on catchment flow data and the now detailed topography model with the digital elevation model with coming from the LIDAR project has enabled a really robust model to come through, and Jo talked about that reliability and the quality of the model in her evidence. I sure hope this never happens in our lifetimes and in the lifetimes of our great-grandchildren, but effectively, given the signals of what's physically in the catchment and how the water responds, yeah, this is the best model we have got to indicate what the potential future risk is going to be. And I guess the regional policy statement tries to manage that risk the best it can. In absence of detailed modelling, it tries to send those signals around, avoiding where there's significant risk. You don't want to be perpetuating risk or exposing communities to unnecessary risk through district plan provisions.
Marcus, I just have a question around, you said for any areas that are prone to flooding, you think for residents it would be non-complying to put any further buildings on that land. Mm-hmm. Would you consider if there was a height restriction there, if you would build up like a building, put a garage underneath for 2 metres or further, could that be discretionary?
I think, well, the way that my view of how the regional policy statements indicated is it's avoid development unless it's absolutely necessary. So where there's a significant risk, there are potentially ways to manage the risk best you can, like putting houses on stilts and those sorts of activities. But overall, the impact of that still may mean there's no insurance and there's other financial implications that could be borne by those landowners. But ultimately too, there's still evacuation impacts that you'd have to work through, and you're still putting people at risk, and the infrastructure associated with keeping those buildings in those locations, there may be still quite a bit of lag time after a flood goes through that people would be displaced. I think you're better off signalling other locations that are more suitable to build from a natural hazard perspective than engineering a way out of the significant risk.
Let's move on to the agreed statement on the area of disagreement. Mm-hmm. I guess you're sitting, describe what the disagreement is over the 0.5 and the 1% between the two of you, what the significance of that is in terms of the decisions we've got to make, and give us an understanding of your position.
Yeah, certainly. So my view was that the 1% AEP return period would be a better approach as opposed to the 0.5%. Purely, I guess, in terms of the notified version of the maps was, I guess, the horizontal extent of where the flood was based was on the 1% return period. Additionally, the impact of those properties, such as Commissioner Bartlett's question around if there's properties that didn't know they were impacted from depth or everyone didn't know the depth, I guess, but in terms of more properties captured by the flood modelling now, imposing 0.5% would have a natural justice issue even more than we currently have for this topic. And I think generally the way things are looking at a national scale, I think they're more focusing on the 1% AEP as opposed to the 0.5% AEP. So that was my justification of why I thought a 1% would be a more appropriate return period to work off for natural hazard risk rather than 0.5.
But but the rules refer to 0.5 and I can't see a submission opposing it.
Yeah, I guess it's just a more precautionary approach. So ultimately, yeah, I'm happy to go with 0.5. If there's no scope to shift it to 1%, then that's fine. I guess that is what it is.
I want to pick that up because that was on my mind as well, and particularly in areas like Mandeville or these places where we do have zoning decisions to make and they're outside the new available mapping, but they also have this reference to the 0.5% AEP. And so, and as Commissioner Havell has said, there's all the recommendations to us at the moment are still using 0.5% minimum floor level in the rules. And so then the question arises, well, how does someone know that? They go to Environment Southland to find that out. And at the point that they do that, Environment Southland's going to use the best available information for areas outside this mapped modelling. And to me that starts to get at the scope questions as well around the 0.5% AEP. It's the difference between go to Environment Southland to find this out, or some of this we know already and you can see, and some of it might already be on your limb. So I'm quite interested in, yeah, the challenge that's been laid down in Ms. Benitti's evidence that says, well, look, you know, this is a step further than, you know, it does raise these natural justice issues, which I can understand that argument, but at the core of it, we do have a notified plan that references 0.5% AEP. Yeah, and as Commissioner Havell said, that's just remained unchallenged through the entirety of the hearing. And the only thing that's different is whether the knowledge that Environment Southland holds is visible in all areas or not. Is that a fair summary?
Yeah, I think that is a fair summary, and I guess you know, something of consideration for the panel was around the changes by stealth after the plan's finalised. So if the plan goes through in its current form of 0.5%, and then the Environment Southland modelling comes out June, July, August, September, some stage in there for the rest of the catchment for the Gore district, then is, you know, what is the impact of that modelling? Are people overnight captured from the modelling being produced because there's a rule in the plan that says 0.5, and all of a sudden the floor height's gone from 600 mils to 900 mils?
Yes.
I guess that's the practical application of having the modelling and having a rule referencing a model that doesn't exist.
But if the rules, and we've got no recommendation to take the 0.5% minimum floor level out of the rules, we don't have anything telling us to do that. So that's the reason that it seems to me that it's only about the quality of information gradually improving, not the responsibility to respond to the 0.5% AEP and design for that response, which has already been part of the notified framework of the plan.
Sorry, just struggling with the question. Which can you reframe that question for me, please?
Well, that was me thinking aloud, probably, and not a very good question framing. So, is the fact that the 0.5% AEP minimum floor level was there in the notified planning framework remains unchallenged through the entirety of the hearing, does that in itself signal a responsibility to respond in design to that using the best available information, knowing that the best available information will continue to improve. I.e. we couldn't see it at the point of notification. We can see more of it now, and we expect to be able to see more of it within the next 6 months. But the responsibility in design was signalled from the outset to respond to that level of event. And is that the primary point?
Yes, I would agree that's the primary point.
Question. If I accept that the models are as accurate as you believe they can be at the moment, does not the model indicate to ES that we continue to look for mitigation management within the catchment, so that yes, the panel has, and the plan should reflect the risk that you've identified, but surely ES will continue to manage the catchment looking for part remedy?
Yeah, certainly. Environment Southland has got a body of work around trying to slow the flow and manage the catchment as a whole, so trying to slow the water down, flatten the peak of floods, and looking at a range of regulatory and non-regulatory methods to seek that outcome. However, I guess it's not able to reduce it probably at the same speed that climate change will increase it. So climate change in future will bring bigger floods on a more regular basis. I don't think the actual data has formally come out yet around any flood peaks associated with climate change moving into our future, but it's likely, like most other catchments in New Zealand, where a 1 in 100, 1% AEP flood now could be a 2% flood in 40, 50 years, and therefore another 1% AEP in 40, 50 years could be a 0.5% AEP in today's terms. So the size of floods are going to continue shifting, and I don't think the mitigation measures in catchment will advance quicker than the climate change is increasing the impacts.
I understand, though, that ES is doing some work at present looking at retaining water areas further upstream, and that work is fairly well advanced. Are you able to provide any further comment?
Yes, certainly. So Environment Southland's undertaking a slow the flow project at the moment. So it's currently a pilot project to look at different avenues of how the catchment could be managed, or certain actions within the catchment that could help support enabling the river to move. So instead of confining the river and putting riprap and rock protection around people's property, trying to let the river put those meanders back in, slow the water down, give it more space, potentially remove stop banks, more wetlands, some of those activities. It's looking at what are the viability of those different options and what impact would it likely have on the catchment. So that work is certainly progressing forwards. However, the tools and the regulatory approach associated with those activities and changes in legislation, there's a fair bit of uncertainty around what regulatory measures would be required as in the future with that, with private property rights, potential compensation. There's a whole lot of issues that are likely to pop up if that pilot project actually comes to a council project that is taken forward and advanced, and the costs and ability to be able to progress that forward.
So I went back and had a look at the Section 32 documents relating to the natural hazard chapter, and there's nothing in those documents relating to why the 0.5% was chosen, and to me it's probably a weakness in terms of the plan provisions. And I don't see anything further that's come to us through the whole of this process that I would see as being a robust consideration of the Section 32 issues. What's come from ES, the focus has been on the regional policy statement and what that says about significant areas. But that's one consideration in terms of Section 32. And there's the social and there's the economic assessment that needs to be done. Have ES actually done any work looking at what I consider to be the Section 32 AA that we need to take into account?
Short answer is no. Effectively, we've just been focusing solely on the hazard risk at the moment with the flood modelling.
So as a panel, if we're making changes to the plan, we're required to do a Section 32 AA assessment. And I have doubts that we have the technical skills that are needed to actually do that in a manner that's appropriate. So what advice can you give us, given that we have a procedural constraint that we need to work through?
Yeah, I think, I guess the panel probably agrees with myself and the other experts in the legal position in the room that we can only advance it as far as we can, given the process we've got and the constraints with the notified plan and the information that came available through the hearings process. I think this is probably just a call for a variation at some stage in the future and a bit more time and consideration to have a proper look at exactly how this natural hazard stuff is grappled up and managed across not just the district but actually a whole catchment. So that's a Southern District Council conversation, that's a Gore District Council conversation, it's an Environment Southern conversation, it's Runanga conversation, it's everybody within that whole catchment process to actually look at all of catchment mountains to sea approach of how our catchment functions, what are the measures, where are we going to enable and disincentivize different activities within that catchment to get good outcomes and what those outcomes could look like. So yeah, I think there's a whole catchment approach needed. We're looking at a pretty narrow focus on purely just Gore at this stage, and we've got some pretty significant constraints around exactly how far the panel can advance, some of the natural hazard management and the rules.
So in terms of our decision issuing, how far do you believe we can go?
I think the notified version of the 0.5% AEP height in the rule framework, I think that's, there's no submissions that are proposing it, that is what it is, then you've got to progress that forward. The only implications of that would be around the comms and engagement once the 0.5% heights are known as that rolls forward, and working through the implications on those landowners as those things pop up. The flood maps associated with the notified version, I believe are indicated on the 0 or the 1% AEP, so there potentially could be an opportunity to try and provide some signals, I guess, through those properties that were identified that there are some significant constraints coming with future development and growth, trying to avoid significant hazard risk in accordance with the definition of the joint statement, so that if they are looking to do development in the future, they've got a reasonably clear understanding of if it's more than 1.2 metres in height for flood depth, then they're looking at a very difficult pathway to do any growth and development, but potentially mitigation options outside of that.
Am I picking you up correctly that the only place that we can have rules is for those areas shown as subject to inundation in the notified plan?
Yes.
And if the panel is uncomfortable with what you've described, until the information is better understood in the wider community, is one of the options available to the panel to request the withdrawal of the natural hazards chapter of the plan until it's resolved and a variation or plan change done that's comprehensive at that time?
Yes, that's an option. It would potentially be a way to address the natural hazard issue quicker than issuing a decision that's not quite 100% where it needs to be, and then putting the reliance back on the Gore District Council to approve a variation. That could take some time to actually get that through the process. Council resolution to do that work. I think it's best to have clarity of development rights, so landowners know exactly what their issues are and what the potential impacts of a plan are on those people. So I think that's something we don't want to spring things on people through this process that doesn't lead to good outcomes either. But ultimately, I think the natural hazard issue is one of those issues that needs to be taken reasonably seriously for future well-being of the community as well.
And just before Cliff comes in there, another option may be available, and we'll get some legal advice shortly, in terms of is it possible to actually put a deferral on when rules come into force in this chapter?
Yeah, I think there are, but I think there's probably a wider consultation process that's probably more valuable by deferring and delaying or re-notifying the chapter. I think, there's definitely the natural hazards information that's popped out since the plan was notified. There's not a lot of people that have actually engaged with that or understand it and understand the potential future implications of that modelling, not only on their properties but also on insurance implications and mortgage implications and those sorts of things. And there's ultimately it almost goes back to the wider spatial plan for Gore as well, as to actually if there's significant constraints in the CBD of Gore, what are the avenues for actually addressing that, and therefore what are the zones that would be appropriate to enable that managing of retreat or relocation of those facilities moving forward. There's a bigger piece than just delaying the rules coming in. I think you'd be better off going to re-notification with all the information across the whole district. I think would be a better process.
Look, I'm not sure who can answer this. If natural hazards chapter was withdrawn or held in abeyance, would that also catch those people who wish to do an activity within an area that isn't flood prone in your models?
I don't think it would. I think if it was in abeyance or didn't progress any further, I guess the operative rules of the current district plan would prevail, I presume. So I guess the current framework that's existed for some time would continue forward until such time as the new rules were advanced to a position where they would have that precedent of having a legal effect, and the weighting would switch to the new rules. So I guess it would just be a signal that things can continue as they are, but there are some changes coming through with the flood modelling information.
Is that sufficiently precautionary with the information we now know?
I think in terms of a regulatory framework, it is probably not as precautionary as it should be. However, I guess the natural hazard advice from Environment Southland at the time of building and development would continue with the latest information. So it would be a bit of a mix-up of old rules and new modelling, and just seeing how those two would intersect, and the opportunities for managing resource consent approvals and where we could through that process. But there's ultimately a permitted baseline within the existing zone structures that would enable growth and development to continue.
And you kind of get the hopefully the message. I'm looking at all options from both ends of the spectrum. Do you think it's appropriate, with the information that we've got, that council is required to give effect to in issuing building consents, to actually have district plan provisions that are saying something different?
Yeah, it gets pretty tricky pretty quick. If the district plan permits it, the district plan permits it. So, or ultimately, if the district plan's out of step, the district plan's out of step, and that's something that hopefully would put some impetus on progressing forward a variation or a re-notification of the chapter again, with a complete picture of all the risk and hazard, and work through that in a proper structured way with the whole community around what's appropriate and what's not, and what are the consequences of that. And that's ultimately, I think, a conversation that Environment Southland should be on as well, in terms of levels of service, future commitments for stop bank upgrading, encatchment, relief and mitigation. I think there's a bigger piece that needs to be drawn out of that conversation than just what zone do we put where based on the risk. Because if that depends, if Environment Southland is wanting to maintain a level of service 1% AEP moving forward, that could be some upgrading and provide some level of comfort. But if it's a 0.5% AEP, then just to try and align statutory functions around what the expectations are of the community and what the community's expectations are, and ultimately the community would be paying for any upgrades through rates, or so it becomes to a conversation around what the community is willing to pay for that level of protection as well.
So I'm interested in, well, I might let actually Commissioner Dixon go then belong.
Look, I'm just wondering, is there some security around Environment Southland having the full maps ready for the catchment of the Gore District in July?
So that's the program timeline for end of this financial year for delivery of that rest of that catchment. So I would need to have a call in the recess just to see how that is tracking. I could make some calls and see what sort of time frame that would be on. But that was the indication given to me previously.
So I want to pick up the fact that we've got some very clear agreement in the joint witness statement around what significant risk means. And that's something that we were obviously interested in getting back from minute 43, but at the core of our minute was the fact that the notified version of the plan was not giving effect to the RPS, which is something we must do in this decision. And that was because the framework as notified did not have an avoidance instruction connected with significant risk. Now that, I think, is what we must address in this hearing process. We cannot issue a decision that does not give effect, knowingly does not give effect to the RPS. Therefore, we now have an agreed definition of significant risk that we can proceed with. And this is again where it gets interesting, because we now have to reconcile that with the wording that we've got to work with in the policy and rule framework we've got to work with. But the Environment Southland position from the outset has been emphasis on giving effect to the RPS, correct?
Correct.
Yeah. So that's largely what we're trying to do here and respond to. So I'm not sure that it's available to us not to adopt a clear understanding of what significant risk is, what needs to be avoided, and what might be managed by way of minimum floor levels. So to me, this brings us back to the same point, which is if the framework directs what significant risk is and signals that further information can be obtained from Environment Southland to illuminate in any given case where significant risk is present and where it is not. Is this simply a matter of what information is visible at the point of notification, what information is visible now and what will be visible in July or September? And regardless, at the moment the rule framework is tied within the inundation map as notified. So what we are doing is ensuring that within the rule framework that sits inside the inundation layer that was notified, there is some differentiation between avoid and manage, significant risk and lower risk.
Yes, I think that's probably the best case scenario for the panel. That mixture of existing notified extent of inundation in the proposed plan, and then potentially using the significant definition as proposed in the joint witness statement, and then indicating, I guess, non-complying if the floor height's above 1.2 metres.
Although we're also constrained by the scope of the submissions lodged by Environment Southland. And the difficulty we've got there in terms of what Commissioner Bartlett has just talked about is that I don't see amongst the submissions, or the theme in the submissions from ES relates to don't upzone areas. There is not a link in the submissions that goes back to the RPS provisions in terms of the whole significance discussion. While what you've presented at the hearings has talked about justifying what's in the submissions by what's in the regional policy statement, that link is missing in the actual submissions lodged. So we're constrained, I think, by the scope of what's been asked for in the submissions, notwithstanding you've used the RPS to justify some of what's in the submissions.
I think that does come back to the, I guess, the role of the panel is to issue decisions in accordance with the law of being in accordance with the regional policy statement. So, yeah, while it may not necessarily be referenced as such in the plan, it's probably one of those matters that sits above and needs to be consistent across all decision making, is that consistency with the RPS.
Okay, so I'm going to ask our legal advisor, and when she gets to speak shortly, to actually address us on that point. So I think the narrow interpretation is that there are things asked for in the submissions lodged, and that is our bound in terms of what we can go. Yeah, so I'll leave it at that. What I'm wanting to do is to finish our discussion with you. I think these guys need to have an opportunity of talking about some of the issues. So I'll propose that we'll actually take a 15-minute break after we're finished here. And we also need to have a talk about a couple of things. I may generate some more questions. So Marcus, is there anything else from you that you want us to focus on?
No, that was all effectively. Yeah, just wanted to introduce those series of maps for those the depth and velocity for both Gora and Mataura, and also the combined hazard risk with those 1 to 6 profiles. Yeah, that was effectively all we were seeking to do.
Okay, any other questions from the panel then? All right, so we will take a 15-minute break and adjourn at 10:40. Now, I'm mindful, what time are Federated Farmers? So they're due to come up at now, how's your day going, Marcus? Are you available? Can we slip Fed Farmers in at 1:45?
Yeah, that's
Won't
fine.
take
I've got
long.
alternative arrangements for child pickup this afternoon, so I can
Okay,
sort that.
so we'll come back then at 1:45 as soon as we've got Federated Farmers and deal with that, and then come back and hear from our advisors. And what is Courtney needing to cover with us? Yeah, so if we're dealing with Federated Farmers at 1:45, she's available then? Yeah. Yeah. Yes. Okay, so we'll adjourn then till 1:45. Thank you.